This meeting is being recorded.
Good morning. This webinar offers closed captioning. To enable closed captioning, click on the live transcript button on the bottom of your screen and choose your preferred method. Welcome to the City of Chicago Department of Business Affairs and Consumer Protection webinar. We have adapted our regular business education workshops at City Hall into these webinars until further notice. Please note, any website or email that I mentioned will be posted in the chat box. For those seeking business license assistance, we strongly encourage the process of license and permits online. Business license can be applied for or renewed online at chicagobusinessdirect.org, or you can call 312-74-GO-BIZ. If you are a part of the BACP Entrepreneur Certificate Program, you can get credit for joining this webinar by sending an email to bacpoutreach@cityofchicago.org. To learn more about this program, please visit chicago.gov/business education. This webinar is being recorded and will be available at youtube.com/Chicago BACP. We encourage all attendees to ask questions. Please use the chat box to send your questions. There will be a Q&A session at the end of this presentation. Please note the views, information, and opinions expressed during this webinar are solely those of the presenter and does not necessarily represent the official policy or position of the Department of Business Affairs and Consumer Protection or the City of Chicago. Today's webinar is entitled Recognizing and Protecting Your Company's Trademarks, Patents, Trade Secrets, and Copyrights, presented by Patrick J. Smith. At this time, I will now turn this webinar over to Patrick for us to begin.
Good morning. Thank you. I hope I got that right. I think I just messed something up.
No, you look good. It looks good.
All right. So good morning, everyone. Thanks for joining. My name is Patrick Smith. I've given this talk a few times for the city, and I'm happy to be here again to kind of walk everybody through, kind of what I do in my job and how I help businesses protect IP assets. And I think the first step in doing that is making sure you know what the different IP assets are and how they can be protected, and also importantly, how it might be lost. So we will get going. One thing about the format, I'll talk for a little bit, and then I'll open it up for questions. Usually people have a lot of questions. I just ask that questions be general, try not to be very specific, because this is an open thing. And as you'll see, I'm here as a teacher, not as an attorney to be your attorney. So I just I have to caution everyone, when you talk to an attorney, everything is kept secret between you and the attorney unless you want it out. So, my answers are just going to be for educational purposes only. And so we'll answer a lot of questions at the end because people tend to have them. And so usually the first question I have is, what is intellectual property, right? So there's different types of property. There's real property, there's personal property, and there's intellectual property. So real property is real estate, leases, houses, real things, real estate, right? Which is, I'm guessing, what's called real property. I don't know if there's imaginary property. Personal property is all your stuff, right? So that's everything that's not a house. When you sell a house, there's this question of whether it's part of the real property, whether it's part of the house, or whether it's personal property, sometimes appliances. Then there's intellectual property, what we're talking about today. And really, those are rights that give you the right to stop someone from doing something. They might even not be the right to do something for yourself, but it's a right to stop someone else. So that's what intellectual property is. And it's really intended for creative things or things that aren't real property or personal property. And so the core areas of IP, so the big ones and the things we'll talk about today are copyrights, trademarks, trade dress, trade secrets, and patents. These are all different areas of intellectual property, all different things that companies create all the time. And they're all different. They protect different things. They have different terms. Some require registration, some don't. So copyright, for example, protects literary, artistic works, things that are created. And the term, if you register it, is going to be either 95 years or the life of the author plus 70 years. And these aren't renewable because that's a really long time. Registration is not required, but we'll talk about that. Trademarks and also trade dress. Trade dress is a subset of trademarks, but these are names, symbols, overall looks of things that people use to identify their goods and services. And what really goes on here is this idea in the minds of consumers that symbol, that thing is some company that I know makes good stuff, or I guess makes bad stuff and I want to avoid. And so that's what's being protected there. And the term, if you register it, it's 10 years and you have to renew it. And as long as you're using it, you can keep renewing it. Registration is not required, but we'll talk about why you might want to do that. Like I said, trade dress is the same thing. It's just what something looks like. Trade secrets, however, these are different, right? This is confidential information. So this is something you as a business have developed, some information that gives you a competitive advantage that, maybe not everyone knows this information, or maybe not everyone's compiled this information the way you have. As long as you're keeping that secret, it's going to be protectable. And registration is not required because usually when you tell someone a secret, it's no longer a secret. So we'll talk about that. And then finally, we'll jump into patents a little bit. Patents are kind of the one unique thing here is you have to have a registration. You have to get government approval for a patent, right? And patents protect technological innovations. And there's two main patents we'll talk about briefly. There's utility patents, which are for something, what it does, and design patents, which is a protection of what it looks like. And that's very similar to trade dress, as you'll see. And one of the things I want you to think about is there's a lot of overlap here between these. So something that's protected by copyright could also be protected by trademark, vice versa, or a trade dress and a patent. So there are overlaps, and just because one is okay, the other one might be at play. So the first thing we're going to talk about is copyrights. And I do this one first because I think this is the one that people create copyrights all the time. And so that's the one that these are the IP rights everybody creates all the time, right? And I have my camera with me at all times, and I take 95 pictures of my kids. I created copyrights every time I press that click button. So this is where we're going to start. And then my circle C here, you'll see that a lot of times. But as we talk about, just because it's not there doesn't mean something's not copyrighted. So what's protected by copyright? Well, copyright protects original works of authorship fixed in a tangible medium. So I bolded some words here, and I think these are the important words we should point about. So original. So, let's say I'm the author, I have to create it, or me and my co-author, we have to create it together. If someone else takes a picture and then I take that picture and then say, well, I have the copyright in this picture. That's not how it works. It's not original. I could get the copyright from that original author, but I can't take someone else's work and pass it off as my own. Authorship. So you have to do something. It's not much, but you have to do something creative to it. And it's got to be fixed in a tangible medium. So this is one of my favorite thing to think about. If I built a sandcastle, that's some sculptural work. I built it and it's creative. Is it in a tangible medium? Well, it's going to wash away eventually, probably, but it's here for a while. It doesn't have to be here for a long while, I guess. So those are kind of the three things to think about when you try to figure out if you created something to protect by copyright. And so copyright typically includes literary works like books, product descriptions, advertisements, things you write that you write on your own. Musical works, so songs, lyrics, specific recordings. A lot of times a recorded song has 3 or 4 copyrights involved. There's the copyright, which used to be called the P rights, in the specific recording you're listening to. Someone could have a copyright on just the lyrics. Someone could have a copyright on just the musical notes or parts of the musical notes. So, musical works can have a lot of copyrights in just one recording. And that just grows by exponentially when you think about it. If they still make CDs that have 12 songs on them, and there are a lot involved. So you also have pictorial, graphical, sculptural works. So these are pictures or sculptures or graphic design things. Anything really that you create and you're being creative with could potentially be a copyrighted material. And it can include displays or prototypes and possibly technical drawings as well. Again, you're creating these things, but there's a copyright. Copyright doesn't protect ideas, only expression. So this gets into it. Well, what if my thing is functional, right? So I have my lamp here. The lamp is functional. Well, the copyright's going to protect the graphical or sculptural features of this lamp, but it's not going to protect the idea of a lamp, the idea that you could create light by plugging something into a light bulb, right? So you compare a book, I have an idea for a book or a brief outline, with the actual book I wrote, the expression. So the idea is not going to be protected by copyrights, maybe protected by something else, but the expression is what's going to be protected by copyrights. And I chose this lamp because it's a Disney lamp. And if you remember, I said that the copyright term is it's 95 years or 70 years plus the life of the author. One of the reasons copyrights last so long is because they had a very strong, let's say, influence from the Walt Disney Company to make sure that they protected the Disney copyrights. And that's why copyrights last so long, is because of this little mouse. So as a company, what are your sources of copyrightable material? Well, I mean, the easy ones are photos, drawings, music, songs, books, but also logos. If you create a company logo and it's more than just a word mark, that it's something different, that could be copyrighted. It could also be protected by trademark. We'll talk about that later. But that's something that could be copyrighted. Websites are a treasure trove of copyrighted material and different copyrights. There's a copyright in the content you write. So, you write a product description. Well, that's by itself protected by copyright. If you put it on a website, well, then that's going to add the different parts. The source code of the copyright, so the behind the scenes language that the computer uses to display the copyright, or display the website, that could be copyrighted by itself. If you have images on your website, those could be copyrighted. But I put from where. Remember, it's original. So if I didn't take this photo, if I took it from a licensed place that I get photos from, well, I don't get a copyright in the photo like that. But if I take the photo myself and put it on my website, I have a copyright in that photo as well. And then the website itself. So you can kind of protect kind of the overall look and feel. So if you look at my slides, you'll see this overall look and feel I've repeated a lot. We have these two gray bars, one at the top, one at the bottom, a little blue box over here, kind of matches the font of the firm I work at, and there's a green. So they have this overall look and feel that sometimes companies will be able to show that overall look and feel, that's a copyrighted aspect of a website, or even some other things. But in your business, let's say advertisements, flyers you create, again, you're writing things, taking pictures, doing things creatively. These are things that could be protected by copyrights. Employee materials, manuals, anything you write might be copyrighted. But the more you get to something really, I don't want to say functional, but something really technical for work, maybe it won't. So a contract, maybe, probably. A purchase order, well, that seems to be kind of functional. There's an old case where that involved kind of a accountant's type page, and someone wanted to protect that designed by copyright. And the court said, well, no, the page is kind of dictated by function. So the purchase order, there could be some artistic expression you use in your purchase order, but that's really all it's going to protect, not the purchase order or the idea of using a purchase order. So you've created all these copyrights. now what do you do? What does that mean? Well, again, if you remember what I said about intellectual property, this means we can stop someone from doing something. And what do we stop them from doing? Well, we stop them from making copies or derivative works. So first, a copy. Does it have to be an exact copy? No, it just has to be substantially similar. Then that's considered a copy. So if you change one word in a book, that's still a copy. I also bolded derivative works because that's a little different. A derivative work is where you take some aspect of a work and you create something new, and you want people to think about that old work when you do it, or you intend to. So you take a character from a book, or you take a scene from a book, something like that. My best example of this is my wife's favorite book, which is Pride and Prejudice by Jane Austen, which is a wonderful book. I enjoyed it immensely. My favorite derivative work is Pride and Prejudice and Zombies, which is a relatively newer version of that movie where they take the characters and most of the settings and then they add zombies and things happen, and it's a lot more entertaining in my opinion. But that's a derivative work. So they took enough that you think about that old work, but then they put it in a new spin on it. So if you have a copyright, you can stop someone from doing that as well. There is a difference, though, between creating a derivative work and creating a transformative work, where you take something old and make it a completely new work. This is a very detailed and very nuanced determination. I won't get into that, but there are times where what might be a derivative work isn't actually a derivative work. One thing you also have to show, though, is access. You have to show that the infringer had access to your work, because if someone comes up with the exact same story, but they didn't have access to your work, well, then it's not a copy. They just happened to independently come up with the exact same thing, which is plausible, I guess. So, and it doesn't have, you don't have to show actual access or bad faith access or anything like that. The George Harrison song, My Sweet Lord, was found to be an infringement of an earlier song. And I think this was the case where, it came out that, he remembered hearing the song on the radio and the tune was in the back of his head. And so they showed access by showing, well, the song was being played on the radio. He must have heard it, he knew this tune and incorporated that into his song. So access doesn't necessarily mean bad faith access. And what happens if you're found to infringe? Well, you can get an injunction, which is an order to stop. You get actual damages, infringers' profits, statutory damages, attorney's fees. These are all different categories of damages that you might be able to get if someone copies your work. What's important to think about is, though, who owns the copyright originally, right? If you are making stuff, you're the author, typically that's you, right? The author owns works. There's exceptions, though. Works for hire, right? So let's say I have a company and I have employees, and part of the job of the employees is to create stuff for my company. Well, then they're an employee and they create works in the scope of their employment. Well, those copyrights are going to belong to the employer, not the employee who is the actual author. If for this purpose, the company will be considered the author. This also applies to commissioned work. So if I hire someone to specifically do something for me, they're not necessarily a employee, but an independent contractor, or they're an artist and I want them to do a commissioned painting of my small house, then they'll do that at my request. And so as long as I have a writing that says I'm the owner and I hired them as a work for hire, I'll be considered the author, even though they're the ones actually doing it. And so this is important because if you remember, the term was either 95 years or life of the author plus 70. If it's a work for hire, it's going to be the 90 years. If it's not, if you can attribute the author to a person, then it's going to be the life of the author plus 70 years. So that's why this is important, in addition to determining who owns the copyrights. And the lesson here is, if you're hiring someone to make stuff for you, for your company, that might fall into any of these categories, make sure you have something in writing that just says, hey, this is a work for hire. Company own them. My company owns them. Do this up front and just getting in writing, and it's going to save a lot of headaches or avoid headaches down the road. So copyright registration and notice. As I said, you don't have to register a copyright to create these rights. This is like an act of law and nature. When I take that picture with my phone, I've created copyrights. But what I can do with that is it requires registration. If I want to sue someone for using my photo without permission, I have to register my copyright. If you don't do that, you can't file a lawsuit to stop someone. And if you remember, I said there are all these different types of damages. Well, the statutes limit those based on whether or not you've registered and based on the timing of registration. So, my advice typically here is if you have something that's very important to your business, core area, core copyright material, that's something you want to register. If you have stuff that's kind of fringe importance to your company, well, maybe we don't need to register, because you'll see, there are fees and costs and registration. So these can add up. So if you have a lot of stuff, you got to pick and choose. So pick the ones that are important, protect those as best you can, and let the outliers be the outliers. Some of the things you can do to help protect is to do copyright notice. So you can put that C, the year of publication, the owner. It's important here, though, you don't have to do that, right? You don't have to put that on there. Obviously, I don't put it on every picture I take or something like that, but it can be used you can use that in court to show, hey, look, I thought at the time that this was copyrighted material. So it's helpful evidence to have. The flip side here is also important as well. Just because you don't see that circle C doesn't mean the work can be copied, doesn't mean it's in the public domain, doesn't mean the author or owner has given everyone permission to use that. So, I think a lot of times people say, well, he put the picture on Twitter, so Pat thinks everyone wants everyone to use it. That's not the case. Just because someone put a picture on Twitter or Facebook, it doesn't mean that, that they give up all their rights. It also doesn't mean they're not going to come after you to stop you using that photo if you're just putting up again. But, just because it's not there, don't think it's free for the taking. So what do you do about registration? Well, registration is handled by the Library of Congress, and more specifically, the United States Copyright Office. They have a website. It is here. There are two ways you can register. Let's say like a simple written literary work. You can do online registration, which is a few forms, just some information, or a mail-in form, again, just some basic information of the title, the type of work, owner, whether it was a work for hire or not. The fees for filing a copyright registration, it can be $45, which I think is the fee for filing online, or $125 if you file by mail. That's the government fee. If you hire an attorney to do it, they might charge between $500 and $1,000. And the fees can really depend on what you're trying to register. And how long does it take? Well, I'd say relatively fast, which is 8 to 14 months. For the government, that's pretty fast, in my opinion. But I've had some go through in 2 months or less time. So, that the time looks long, but it's not always that long. And so you can kind of move to the end pretty quickly if you need to. So we're going to jump from copyrights onto trademarks now. So trademarks, I put these three things. Maybe you've seen them out there. There's the circle R, which is only to be used for registered trademarks. So if you've got a registration from the U.S. government, you should be using that circle R. You don't have to, but I think it's worth it. TM, that's for you don't have a registration or registered trademark. You can use that TM to let people know, hey, I'm using this term as a trademark. And then SM is service mark. Same thing with the TM. When you don't have a registration, you use it to let people know you're using this mark as a service mark, and you're trying to create rights and use it as a source indicator, right? So trademarks again are words, symbols, logos, things. We'll look at some fun things in a moment here that a business uses to identify its goods and services and distinguish those from others, right? So I'm going to say trademarks. Service marks are the same thing, but for services. So the marks are these things we use to identify my goods and services and distinguish those from others. If you remember, I said this is where the consumer looks and goes, I know that symbol. Those shoes are great. They see that symbol, they think quality, they think they like them. And that's this intangible goodwill that is protected by trademarks. So we'll jump right in now. You know, they could be word marks, right? So you can have a word mark that's just a plain word. It doesn't have to have any special design or logo or anything like that. That could be a trademark. But there are kind of this ranking of whether or not a word can be a trademark. So I always use this shoe store example because I think it's kind of easy to remember. But generic terms aren't going to be trademarked. So you can't trademark a generic term, right? So if I wanted to use shoes for a shoe or vice versa, shoe as my mark, that's not going to happen. That's literally what it is. I'm not going to be able to say I have a trademark in shoes for a shoe. So people always then like to jump up the ladder and go to descriptive because they think, oh, that's really great. It's really close. It's not really generic, but it's close. And it is, and there are some benefits to doing that. So if I did shoe land for a shoe store, okay, it's not really, you know, a land of shoes. It's not generic, but that's kind of descriptive about what it is, right? So, you know, it's not, it's not generic, but it's not suggestive. So it kind of falls in between, I think. So it can be registered, but only with secondary meaning. So secondary meaning is your ability to show that connection in the consumer's mind. We'll talk about a few examples where this has happened. But how you do this is you come in and prove and say, hey, people have been waiting outside for this shoe store to open. People know me. I've been doing this for 20 years. I spend all this money on marketing. And if you can do that, then they'll say, okay, all right, it may be descriptive, but you've got a little edge here. If you want to avoid that, you jump up the ladder and you go to suggestive. A suggestive word mark is something that it does that. It creates that, makes you think about the connection, but it's not literally the connection. So laces up for a shoe store. Well, lots of things can be laced up, but laces up is kind of like you tell your kid to tie his shoes. So it's creating this connection in the mind of, oh, wait, there's probably shoes in that place. And so it's suggesting to the consumer of what I have in my store. I don't have to prove anything with that. It's a suggestive mark. If I'm the first to use it, I can get rights in it. You can go further, and this tends to help you get a stronger mark, is to get an arbitrary mark. So I pick something that has nothing to do with shoe stores. I say my shoe store is Pickles. And I'm unaware of any connection between pickles and shoes, suggestive or otherwise. So Pickles is my shoe store. It's an arbitrary word, has nothing to do with shoe stores. And I'm going to get a little broader protection because what are the chances someone else is going to pick that arbitrary term for the same thing I'm doing or something similar? I can go even further, though, and I can come up with a made up word. So I use jub, which is a word I did not make up, but it's from a home. But jub is a made up word. There's no word. And I use a made up word, a fanciful word for my thing. Again, what are the chances someone else is going to make up that exact same word? It's plausible, but maybe not. And so fanciful marks are the strongest type of word marks you can have. And then so we go back down. So we want to avoid generic marks. Descriptive marks are okay. Suggestive marks, good. Arbitrary, very good. And fanciful, the best. So word marks can be plain. So just be that word. Or they can be stylized. They can have a fancy font. You don't have to do that. You can get registrations on both. If you have a plain word mark, or if yours is a stylized, you can get a protection on the plain and the stylized. You can have a color claim. So you can have specific colors or no colors. So we have a couple examples I'd like to give. And so this is a stylized mark, right? This is a stylized mark of Wilson. And I picked this one because if you didn't know this, this is a Chicago company, or they were at the time. And I grew up near Bryn Mawr Avenue in Chicago, so I always like to see it. But you see they have a stylized Wilson, right? So this registration is going to protect this version of the term Wilson. One thing to note here is, well, two things. One, it tells you what goods this is for. So they're not claiming whenever you file registration, you have to identify the goods and services associated with that. So they have identified sports bags, duffel bags, backpacks, all these bags. The other thing here is if you see on this column, it says section or SEC period 2F, section 2F. What that means is they had to show secondary meaning. My guess is Wilson is probably somebody's last name. And if your mark is primarily a last name like Smith, you have to come in and show that secondary meaning. Last names or terms that are primarily last names are considered descriptive. So you have to show some sort of secondary meaning. So they were able to do that. And so they got this registration, which is a few years old. Moving on, here is a plain word mark, although I guess it's fanciful because they combined it together, but this is another favorite. So the mark is 2 all beef patties, special sauce, lettuce, cheese, pickles, onions on a sesame seed bun. So, and you see the classes here, they have t-shirts as well as hamburger sandwiches. Obviously this is a McDonald's mark, and I recall one of the promotions they did as a kid was they gave out these little records, and to see if the people could do this without messing it up. And if they did, you got a free Big Mac or something. So I always like this mark. But again, you'll notice this section 2F. Well, this kind of describes what they're selling, right? Their Big Mac has some beef patties with some sauce, lettuce, cheese. Anyways, so they had to prove to the trademark office that people hear this, they think McDonald's, which they do. So moving on from word marks, you can have symbols, right? Symbols can be used as a trademark. So here we have a symbol, and I picked this one probably because most people have it on something very close to them right now. And also you'll see at the bottom that this has a color claim in it. So they identify specific colors that are features of this mark. My thought is they probably had to do that to distinguish this mark because this is kind of a common symbol. So they're really taking the symbol logo and combining it with color to create some specific logo, so that's why color can be useful and important for protecting your mark. Another symbol or logo is this one. And I think if you're like me in downtown Chicago, you're probably very familiar with this one. And as a brief aside, the intellectual property disputes behind this logo are really interesting. The whole story behind it is kind of worth the read. Occasionally the stories will pop up in newspapers, and if you have a chance, I recommend it. But this logo is pretty popular and famous, and it's an image, and there's no words, and this is just for basketballs. Obviously, they probably have 100 other registrations for this logo, but this is an example of a logo that you could have in your business. So getting beyond the words and the logos and symbols, there are other things, these non-traditional trademarks that people have protected. So sound, if you watch any of the NBC shows, they have that chime at the beginning, or the Universal Pictures. I think those are the Minions. They sing the little tune. So sound can be a trademark. You hear those things, oh, I know the company that makes those. You don't have to know which company it is, but you know that, oh, that's a company that makes the color. So there's the robin's egg blue for jewelry, Tiffany packaging, right? There's only one company that's making jewelry boxes with a blue, that blue color. Fragrance. These French dolls are associated with this vanilla scent. You have one of these dolls that smells like vanilla. So they are able to stop people from using the vanilla scent on dolls. Product design, packaging, business establishment. These are like trade dress. We'll talk about these in a sec, but like a Coke bottle, the old glass Coke bottle, or, you know, how the McDonald's looks. So, you know, they have you know, whether you go to McDonald's in Chicago or in Ohio or up in Wisconsin, they all have a very similar look and feel. And so those elements have been protected. You also do fabric designs, patterns. You know, Burberry has a lot of IP in the trademarks in their different pattern designs. So like copyrights, though, trademarks can't protect functional things. So if you're using something that's non-traditional, well, it can't be a purely functional thing. So I put green color. And to be honest, I've lost track of where the courts have decided this issue. But, you know, there's a company that makes tractors and other farming equipment, and they typically use green, very specific green color. And, you know, some courts have said, well, that's functional because it matches the grass, or, you know, the farmer wants to have all his equipment, his or her equipment match. So, you know, the company should be able to stop people from using the color. So there's a question about whether color could be functional or not. So you have to remember, if you're doing something non-traditional, it's not going to protect anything that's functional. And again, it has to be distinctive. So it has to be able to create this connection in the minds of consumers that I see that, I think of some company that does that. You don't have to know the company, but you just know that there's an association. So where are you gonna encounter trademarks or service marks in your businesses? Well, your company name, right? That could be a trademark. Product names, if you sell things or you have different product lines or you have service levels, those could all potentially be trademarks. Logos. So if you have a company like my firm here down the bottom, and we also use a logo. So we have this little, which looks like the power button turned to the rotated a bit and has a specific color, you know, that's the logo. So in addition to operating as a trademark, though, there's some level of artistic expression added there. So that could be protected by copyright as well. So, you know, there is some overplay here, and it's important to remember that. So who owns the trademark, right? We're using these trademarks. Well, who owns it? Well, in the US, it's either the first to use it or to file for a registration. Maybe. It does depend. In the US, rights are required to maintain through use. So when I start using a mark and no one else has used that first, I can start creating rights in this mark, right? There is an exception of being able to file a trademark registration, file a trademark application based on your intent to use. I'm going to start a company, I'm going to use this mark, and we'll talk about that. But if someone does that, even though they haven't used it mark, they're going to get that earlier filing date, which could impact your rights. Because in the US, registration is not required. So I don't have to file for any trademark registrations to have rights. Again, they're required to maintain through use. When I start using it, I could potentially start generating rights. But we'll see, registration does enhance the rights. It helps you out. As I mentioned at the beginning, if you have trademarks and you haven't registered them, you might want to use the TM just to let people know, hey, I'm using this as a trademark. If you have a registration, you might want to use a circle R to let people know I have a registration for this trademark. If you use a circle R without having a registration, you can get in trouble. And if you file for registration, you send in examples that show that, the trademark office will ask you to remove it. So don't use that R unless you have the registration. And if you don't, use the TM. Most states also do have a state registration system where it allows you to register trademarks. I honestly don't use that very much in my practice, if at all. I know people have, but there is a possibility to do that. It's a different system and they look at different things, but something to consider. Outside the US, it's kind of a little different because it's usually the first to file for a registration. So if you've been using it, but you didn't file first, well, you may not be able to use it anymore, or someone could beat you to the punch and make you stop or limit your rights. So in the US, using it or filing an intent to use is the first way to stake your claim. And now you have trademark rights, let's say. What do you do with it? Well, actually, you have to do something. You have to police it. It's an affirmative legal duty because the goal here is to protect this consumer confusion. I don't want somebody to see another mark and wrongly think that that's me, right? That's why people always sue over trademark infringement. They think they're creating this confusion. But if you as a mark holder are not out there making sure no one's doing this, well, you might lose your mark. So marks can become generic if not policed. And if a mark becomes generic, you'll remember you don't get protection. So aspirin, all right? Aspirin is generic for acetaminophen in the US. Outside the US, aspirin is a trademark that's protected by Bayer. But inside the US, the trademark wasn't policed. People started using aspirin generically for acetaminophen and they lost trademark protection. If you're bored and you have time on the L or something and you want to look up, there's always fun lists of terms that we use every day that used to be trademarks, like laundromat, escalator. So those are always kind of fun to see, who didn't do it or who gave up or what is now generic and what didn't be. How do you police? Well, you can just do searches, right? Search your mark, see what comes up, make sure it's you and nobody else. If it's somebody else, well, maybe we'll have to write a letter. You can pay a company, it's called a watch service, and they'll watch for people who file trademarks that are close to yours and let you know and say, hey, Pat, someone filed something pretty close to you. Do you want to maybe tell the patent office about yours or do something? So that's something you can do. But if you find these people, you got to write them a letter or start some sort of process or do something that shows I'm trying to stop this act that I think is confusing. Because if you don't, and people keep doing that, there's this potential that your mark becomes generic. So how do you what's the proper trademark use here? Well, kind of distinguish the mark from the surrounding text. So you look at my next example, right? UGG is capitalized or Kleenex is capitalized. So that's distinguishing the mark. But you always use mark followed by a noun. So if it's for boots and my brand is UGG, I'm going to say UGG boots. I don't say, look at those Uggs. I say, look at those UGG boots. Same thing with Kleenex. I don't get a Kleenex, I get a Kleenex brand tissue. Again, don't use the plural, use pluralize the noun, not the term. Don't use the mark as a verb, right? Xerox or Google, you don't tell people to Google something. You tell people to do an internet search with the Google search engine, or tell people to make a copy at the Xerox branded copier. The Google and Xerox are companies that undertake some advertising, you'll see, to remind you, hey, these are marks, not verbs. So that's their policing, that's their action they're taking to show that they're not giving up the rights to these terms. Importantly, you got to use it in commerce, right? So as I said, trademark rights are created mostly through use. And so you have to use it in commerce, and it should be honor and association with the goods. So if I'm using stuff back of the house where none of the consumers see it, well, that's not in commerce. If I slap my label on my shoes, that's in commerce, that's good. Or on the boxes of my shoes. One thing to note is that use, though, can be through a related company or with a licensee. So if I have a bunch of IP and I license someone to make my shoes, and I say, all right, I'm done. I'm going to go fish now for the rest of the year. You take over. I can let them do that, and their use will provide me the benefit of use of my mark. But one thing I must do is I have to do quality control. I have to retain the right to reject goods. I have to say, all right, you're going to use my mark, and I'm going to get the rights to it. but I have the right to reject goods if they don't meet my high standards. So if you're licensing this, you can't just give a naked license. You can't just say, go ahead, use it, I don't care. You gotta keep some skin in the game there. You gotta make sure you're keeping that quality control, because you gotta protect that association, that connection of, hey, those are really good shoes. And so I've talked about this, common law rights versus federal registration. Again, we don't have to file a registration. So common law rights, if you're just using the mark, typically you're going to be, your protection area is going to be bounded by the geographical area of use. So, if I use it here in Chicago, well, I might get protection in Wisconsin, maybe parts of Indiana, but it's probably just going to be right around Chicago, my area. And I actually have to have a product or service on the market. If I haven't filed any registrations, but I'm doing stuff inside, I've closed, I've got my shop ready to go, I've got my shoes marked, but I haven't started selling my shoes or advertising them, well, I haven't created any rights. Even though I put it all on the shoes and I'm getting ready to open, I still have no rights I've created. So that jumps to the next point is, if I'm doing that and somebody jumps in front of me and says, he's taking too long, I'm going to sell these shoes, I'll be out of luck. That person starts using them first, they're going to win the race and they'll beat me to it. So if that's a concern, then maybe we want to think about federal registration, right? First, it's valid in the whole country. So again, if I'm only in Chicago working on people who come from Indiana or up to Wisconsin, but I have a federal registration, I'm protected everywhere. People are on constructive notice and are throughout the country that I'm using this mark. This also allows me to file this intent to use application. So if I'm getting ready to do stuff, but I'm not ready to do stuff, I file an intent to use application, and this application is filed, and it's like a placeholder. You file it and you tell the trademark office, hey, I'm going to use this mark. I'm just not ready to do it yet. They'll examine it, they'll approve it, and then they'll say, okay, everything looks good, Pat. You have 6 months to tell us you've been using it and prove it. I can extend that for up to 3 years, but they'll approve it and you got to use it in order to get the actual registration. But it allows you that time to expand at your own pace, right? And the date I filed that application is the date of first use, or my earliest date, even though I didn't use it. So this is really, a beneficial thing is, if you picked your marks, but you've got some time before you're going to start using them, you may want to file this to protect them. And one final thing, it is one file. There are many other benefits, but one other thing that's worth pointing out is, if you have a federal registration, you can register it with the customs, and they can, stop goods that are using, any goods that use infringing marks or something like that, or unauthorized goods that are coming into the country. That's another way you could police your mark. So federal registration, how do we do the registration? Well, the trademark office is part of it's actually the U.S. Patent and Trademark Office, is part of the Department of Commerce. Here's their website, the general one and the trademark one. You can file, again, online or in paper. The fees differ whether you file online or in paper. They really want you to file online. And if you remember, you have to list all the goods and services you do. So if you have a laundry list of things, the fees are going to increase. If you keep it limited, that'll keep the fees down, but then again, your protection might get smaller. So you have to do this balancing. How fast? Relatively fast. Usually the trademark office aims to get you a first decision within 6 months. And what the decision will be is, I think they'll go through formality issues, that we don't like how you described it, or you have to disclaim a part of your mark. But they'll also compare against other marks registered and filed to see if they think there's anything confusingly similar. And you may have to respond to that. So you can go to their trademark office, this search database. I think that's the website, and do your own search, plug in terms, and see if the marks are filed or abandoned or what's out there. Trade dress. So I'm going to go a little quickly through this one, but trade dress is just like trademarks for the most part, right? It's protecting this connection, but based on the overall design configuration of a packaging or something like that. So again, it's really a type of mark. So it could be the overall look of the store, configuration of packaging or product. So I just do this quickly and go over a couple examples or what happened. So this is a case where I think the vitamin water, the one on the left, was the one who had the trade dress claim against the one on the right. And so they went through these things and said, well, is this an infringement? Is this confusingly similar? Well, they're both in bell-shaped plastic bottles, vertical words, two-tone look where one of them is clear and the other matches the liquid, clear cap, overall clinical look, whatever that means, and all this stuff. So they looked at these factors because the person on the left was saying that the one on the right is too close. Here's another trade dress. So this is for, and interestingly enough, you can see closely that little circle thing in the bottle, the navel, that's what it protects. The bottle shown in dashed is just an example, right? So someone has a registration for this trade dress, which is this essentially a bottle with a navel in the middle. This is another one. This is older, but this is another one where you'll see they have a pretty specific description of this registration and this thing that became the subject of many lawsuits in the IP world. And you'll see this one will come back again when we talk about patents. So again, similar to trademarks, but you have to remember there's no protection of the functional aspect. So if I jump back real quick, this registration for this trade dress, it protects what it looks like, not what it does. So if the phone did something new, this trade dress registration wouldn't protect that at all. It would only protect how it looks. And again, so if you have trade dress, it's got to be distinctive though. So it has to create that impression. So whether inherently or with secondary meaning. And in general, that requires a lot of evidence. So the iPhone one, that one, they were able to show the number of sales they made immediately. The first day they release it, the fact that people camp out in lines for weeks to buy these phones, they could show such a consumer demand and recognition of this phone looking like this, that they were entitled to the protection that they got, according to the government. And the protection is similar to trademarks. So we could stop people from using marks, trade dress that's similar. Trade secrets. So we'll talk about now this trade secrets. Again, these are things that are secret, right? So these are formulas, patterns, device, methods, processes, anything really you use in your business, which provides you an advantage over competitors who don't know it, right? And there's a lot of things that this could cover. We'll go over some examples, but this could be a lot of stuff. Important things to note, though, it has to be confidential, and you have to take steps to keep it confidential, right? So if I say my customer list is my trade secret, but on my website, I put my customer list, well, that's probably not going to be confidential. They're considered confidential, at least at that level. So trade secrets, there's no system for registration, right? You don't want to give the government the secret stuff because it might get lost, or there's no process for registering it. You prove it in a lawsuit. So this comes out when someone steals it, or someone is about to steal it, or someone leaves and starts a competing business and you think they're going to use your stuff they stole. And it happens to be proven in the lawsuit. So you go through the lawsuit and you fight about whether or not you have a secret or whether or not it was secret enough. And that's kind of where that you prove it, you had a trade secret. And the important thing here is you lose protection once it's no longer a secret. Even so, if somebody steals stuff and discloses it to everybody, well, you lose out. Now, you can be compensated for that, you get some damages maybe, but if you lose the secret, you can't protect it as a secret. So that's really important. So what are your potential trade secrets that you might have in your company? Well, business plans, strategies, what you're going to do, how you're going to expand. who you're going to go after, customer and supplier lists. So, I gave this example of I just have a list of customers. Well, that's not going to be a trade secret, just a list of customers. If you've ever watched the show The Office, right, and Michael Scott, he has this Rolodex on his desk and it's his customers, but he has all these codes and information and all this data and stuff that he's compiled over the years and he's put on that customer list, the Rolodex he uses. That's a trade secret, right? That's what's protected. Not, a list of 12 people that I sold my goods to or do services for. That's probably not enough. So if you have that compiled information that really is, something special and gives you an advantage, well, then that's what's going to be protected. So business plans, this could be, how you're going to change your business or do whatever. That could give you some competitive advantage. Employee compensation. So maybe, you get the best employees because nobody's supposed to talk about what they're making with other employees. So that employee compensation could be a trade secret. Non-public recipes, designs, formulas that can't be reverse engineered. So this is the greatest example of this is Coke, the Coca-Cola formula, right? No one's been able to reverse engineer whatever that soft drink has in it. So as long as that's the case, that they'll be able to protect that formula for a trade secret. And if someone does ultimately figure out what's in there and they have every right to make it. As long as they don't steal the secret to do it, they have every right to make it. And once they do, Coke might lose its trade secrets there. So on that, if you make food for people, so if you have a special way you make your chili or your salsa or something like that, that process could potentially be a secret. If yours, same ingredients, but you cook it a little different and everybody says, oh man, I'm buying yours. Well, and I'd say you might have a trade secret in how you're making your products. So you want to protect that. So how do you protect it? How do you keep the secrets secret? You market as confidential. Access is limited to employees, contractors who need to know. You have agreements to maintain in confidence. So employee agreements, you can work some of these things in. If you have some of this stuff is on a computer, well, you password protect it, right? Whether it's a document or the computer or something like that. Maybe it's as simple as locking your doors. There's cases where they've asked that. What a court is going to do here is they're going to look at your business or the other business and say what's reasonable for that company, right? If that company left the doors open, computers logged in, and anyone could just come in and access that information, well, a court's not going to be very helpful there. They're going to say, well, you didn't do anything. But if you're a small company, they're not going to require you to have, security cameras and a dog watching at night and all these things protecting your secrets. No, it's just reasonable for your company. So these are just some ideas that you could come up with to protect things that you think might be secrets. And moving on to patents. Patents are things that could have been trade secrets, but you file for a patent and thereby disclose it to everyone in exchange for the monopoly. So patents are different, if you remember, because they're the one that I said you have to have a registration. So patents grant the right to stop others from making something, using it, selling it, offering it for sale, or importing it. What's important to note is it's not necessarily the right to make it. So if I come up with a new drug and I get a patent, that doesn't mean I can make the drug. That just means I can stop people from making the drug. Some other branch of the government's going to tell me whether I can make it or not. So it's important to remember that. The basic requirements for something to be patentable, to get a patent, it has to be useful, novel, and non-obvious, right? Useful is pretty low bar. It has to have some tangible use. I'm pretty sure if you come up with something that's potentially patentable, you'd be smart enough to come up with a use for it. Novel, what does that mean? Well, it has to be new. Someone out there couldn't have done the exact same. So if I come up with a new phone and someone else has done the exact same phone before me, well, then it's not novel. Well, what if I come up with a phone that's not exactly like that previous phone, but it's a little different. Well, then it's a question of, was that obvious? Non-obvious. So it has to be not obvious. And in my day job, when I'm helping people get patents, I'd say fighting about whether something is obvious or not obvious is what I spend a lot of time doing. And that's kind of what the fight at the patent office often boils down to. So how do you know if this is the case? Well, you can conduct a patentability search. So you can contact an attorney or someone else, or do it yourself. Go to the internet search engine Google, and they have a patents sub search, and you can put some terms in, search stuff, and see what's out there. You'd also conduct a non-infringement search. So that's making sure no one has a patent on something I'm going to make. You might want to do that. Timing, this is kind of important. So in the US, you have to file for a patent within 1 year of your first public use or disclosure. And in the US, the sooner you file, the better. So if I have a trade show, it'd be better to file before the trade show. But if I have the trade show, let's say, I didn't file for trademark or for a patent, I had the trade show, I have a year from that trade show then to file for patents in the US. Outside the US, most countries won't let you file after you publicly disclosed it. And when it comes to utility patents, you could file what's known as a provisional patent application as a placeholder. So this is like, I quickly file something before my trade show. I have my trade show, and then I draft up the full application. You have a year to file the full application, but this is a way that allows people to get a patent application on file within that 1 year deadline, because sometimes things happen quickly, and so they want to be sure you can get something filed. So there are really two types of patents we'll talk about. There's utility patents and design patents. There are also patents for plants, of which I have never done any, but so if you're a botanist and you have new plants you're creating, you can protect those new plants via patent. But that seems to be the very limited number of cases. So we'll talk about utility patents, which are for useful inventions. So the functional features of a machine or a process or manufactured thing, or design patents. So this is almost like trade dress, what it looks like. And so it can be used in conjunction with trade dress. But that won't cover any functional features, just like trade dress. So this is an example of a utility patent, what it looks like. So the cover page has some information, title, the name, the date of the patent, patent number. And then so if there's figures or drawings, I'll usually have one drawing on the front here. There's one, and then a couple pages of drawings which have mushed together. And on the right side, you'll see there's some columns. There's a 2 at the top, a 4. There's columns of text. So it's a bunch of pages. This is a patent for a method of swinging on a swing. And this is a patent that I believe the backstory was a patent attorney wanted to show people how I don't know, how the patent process can be, tricky or something like that, or maybe you can convince someone that something's not obvious, or so this attorney ended up getting this patent and kind of talking about it, and actually the patent office revoked this patent. They went back after it was granted and pulled it back and said, you know what, we shouldn't have granted that. So there's kind of a funny little side story behind it, but this is what a utility patent looks like. This is what a design patent looks like. So you say the first page is similar, right? There's background information, the name of the inventor, the title, a number, the date of it. There's some images on the bottom, because a design patent covers what it looks like. Design patents are really short on text, and really long in drawings. And so this is a fun one because it's for a grill that looks like a pig. I'm happy to report that this design patent is expired, right? So it is no longer enforceable as a design patent. I don't know, maybe there's some copyright here or some trade dress that would still be there, but presumably, assuming they don't have any rights there, we're all free to make this pig grill. Here's another design patent. I don't know the number, but this is just like the trade dress that we looked at earlier. So in addition to getting trade dress, the Apple was able to get a design patent on this, this overall shape design of this. And actually, I do believe it really only covers the display screen. You can see everything's kind of dotted around that. That typically indicates that doesn't cover, that's not part of the claimed design. And so, and why would the company do that? Well, again, if you remember, trade dress lasts as long as you're using it. Design patents have a fixed term of 15 years. So while Apple's using that specific design, they have both. But let's say they stop using that first design and come to a new design that's completely different. Well, they might start losing rights in that design because they've given up. But they have a design patent that's good for 15 years. It doesn't require them to use it. So they can use the design patent to stop people from then coming behind them and saying, all right, well, it's not confusing because you're not offering it. Apple can say, no, 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 I have a design patent. You still can't do it. So, you know, a lot of companies will intertwine these protections, and it doesn't have to be just big companies. It could be small companies. So you have to always remember, are there other ways I can protect this asset of my business? So what could be patented? Well, this used to be the statement that anything man-made under the sun that meets the statutory requirements, right? So that could be a product, item, device, thing, processes. The patent office is like a pendulum, and what's patentable and what's not kind of swings back and forth. So a while ago, a lot of people got patents on business methods. Well, then courts got involved and they said, no, I don't think that's stuff that's patentable. So now you can't get a method. So there's this swing. And one of the things that's kind of caught in this current swing is computer software. And so the question is, can you get computer software? Yes, you can get patents on computer software, but it's difficult. It's not as difficult as it had been, but it's more difficult than it once was. But you know, that's just how life goes, and you work with what you have. So it's still potentially anything under the sun that's man-made, but you know, sometimes the different things have a harder battle at the patent office. So if something's patented, usually they're marked with a patent number or patent pending. And in fact, you have to do that. If you want to claim damages, you got to be able to put patent number or patent pending on your device. Otherwise, you're going to really limit yourself on damages. And somebody infringes if they make, use, sell, offer, or import the invention without your permission. So they don't have to know you have a patent, right? They don't have to know anything about it. They just start selling something and that's covered by your patent. They could potentially infringe. And there are some serious damages, you know, monetary damages, which can be tripled, attorney's fees, injunctions. You know, if you get a letter like this, a lot of times you go to an attorney, get an opinion that says, no, you're not infringing, go ahead. Because even if you do, the opinion helps out to say that you were acting reasonably. But, you know, that's kind of where the infringement comes in on patents. So who owns a patent or invention? Well, it's kind of like copyrights. It's typically owned by the inventor, right? The person who came up with the idea. But if it's an employee, then the employee or independent contractor is probably going to have a writing, and that's going to go to the owner. So the important thing here is to make sure that's in writing, right? So each state can kind of has different laws about who owns stuff like this. The best thing to do is have a writing that says, hey, employee, anything you can create in the course of your employment working for me, I own as the company. There is this caveat. Illinois has this caveat that says Employee Inventions Act, which is to say, if you have that, and then the employee goes home at night and does stuff in their garage, the stuff they do in their garage is not involved in your contract. So if anyone ever complains or says, oh, what about what I like to do in my free time? It's still their free time, they still get that. This should go, though, in your contracts with people creating stuff for you. So obtaining a patent, as I said before, registration is required. So this is the one that you have to do, right? You have no patent rights until the government tells you you have patent rights. Obtaining a patent is costly and it does take time. And once you get a patent, like a utility patent, you still have to pay maintenance fees. So you get it, then the 4-year, 12-year, and 16-year, you have to pay the government to essentially tell them, yes, I'm still want to protect this patent. Otherwise, if you don't, then it's going to go expired. It's going to be considered open, free for everyone to do. And people do that all the time. They let it go, things go expired, but they also keep patents around for a long time. As I mentioned before, it doesn't mean or doesn't require you to make anything or otherwise use the patent. So if I have a patent on a phone, I don't just make the phone. Again, it's my right to stop people. And so that's an important distinction here. And it also doesn't, getting a patent doesn't mean you have to have a working product or prototype or, as long as you have an idea in your head about your invention, something new, you can talk about it, explain it, and you can write it so you can describe it so that someone could build the prototype, then you're ready for filing for a patent. You don't have to actually build the prototype, but you actually did have to do that a long time ago. And so there are these, people have these small examples of devices and stuff like that when this was a requirement, but that was, over 100 years ago. That's not an issue now. And one thing to know is that protection is defined by the claims of a patent. So if you remember my picture, all these numbered are columns of text. At the end, they end with these paragraphs that say, we claim a very confusing description of what's protected. And, the patent could show 1,000 different figures, but it's not necessarily the figures for a utility patent. It's the claim. It's the written word and description of what's protected. So that's always the important thing to remember. So the patent application process. So again, this is part of the Department of Congress, Patent and Trademark Office. They share a website, but change after the backslash, you go to the patent side. Again, you can file online or in paper. I think these fees are right. I didn't check, but I think this sounds right. It's cheaper to file online. You don't have the new way they do their fees. They add surcharges in if you file in paper. So filing online is preferred for the patent office. Just to give you an idea, what a patent attorney would charge for preparing a utility application, it can be, between $5,000 and $10,000 to write an application. So again, this is a costly process, but for some companies, it's important because it's a core IP they need to protect. You don't have to do any searching, right? The patent office is going to do the search for you when they examine. But this is kind of like insurance. Before you spend that, $5,000 to $10,000 to hire someone to write a patent, maybe you want to spend some money or some time to make sure there aren't any patents out there that are pretty close. And so you can go to the patent office website or this other search engine here that I like to use. You can go there and look and search around. One thing to know though, patents are kept secret for 18 months. So all the patents that are being published now were filed, a year and a half ago. So there is a lag between what's been filed and what's published. So there is a little space for stuff that we don't know about to exist. And so it's always important to remember that. Well, once you prepare it, you get it filed, what happens? You wait. Unfortunately, you probably wait for a year and a half, 2 years. And sometimes it's faster, but that's probably on average. And as you go through the process, you do have to pay more fees to the government for the different steps sometimes. And so that it does, over the life of filing a patent and getting it to issue, it can be costly, something to think about. So if you have something that could be trade secret or a patent, you may have to determine and sit, the cost versus the protection involved, and kind of do this balancing act to figure it out. Design patents are less expensive. The filing fee here for a small entity is only $500. And so, and again, that application is much shorter, and the process is a little faster. Provisional applications, so remember, we need to get this filed pretty quickly, and we want to give ourselves a year to draft a full application. Those are the filing fee is really small for that as well, because you file that and nothing happens. The patent office puts it there and says, okay, here's your number, patent, your date. And that's all that's going to happen with that. So that's not expensive to file, and it gives you a year to shop around and to disclose and to see what kind of interest you have before you have to, undertake this full patent application, the timing and the cost of that. And so I've kind of stopped talking, run out of things to talk about from a high level about all these areas of intellectual property. And I'm going to do that. And so I hope, I've given you some ideas and things to think about, both in terms of what you might create in your business and how you might protect that. And then as well as things, the overlap that'll be there, and that, well, I may have some logo protection here. I might also have some trademark protection here and some copyright protection here, and to kind of use those the best to your business and really protect those assets, because that they aren't real property and they aren't personal property, but they're still tangible benefits that your company can see, intangible benefits and assets your company has that will protect you and help your business grow and succeed. And so I believe we have some questions in the chat and the Q&A. And so let's see. I could start in the chat. And again, as I said at the outset, I'll try to answer all these questions really quickly. And again, I'm here as an educator. I'm teaching, taking a break from my normal job. So I'm going to give just general thoughts on the questions. And so, if you have other questions, feel free to, reach out to me, or if you want to talk individually, I'm always open to answering my phone if I'm in the office. If I'm not, leave a message and I'll call you back. But, shoot me an email or something. I like this area of law, so I don't mind talking about it. So let's see. In regards to copyrights, if you go on Google, search for a specific image. All right, so are you creating, if you went to Google and took a picture? You might be, right? You don't know who took that picture, whether they dedicated that to the public. So every time you take a picture, you create copyrights. If someone can dedicate that to the public and say, you know what, I took this picture, I don't care, everyone can use it, go ahead. So just because the pictures comes up in a search engine result doesn't mean they can copy it and use it and put it on the website. This next question is interesting. If you're a student and you make something as part of your dissertation, does the school have any rights to your work? Well, I don't know, probably not. I think a student is not an employee, right? There's probably no writing that says anything I create, the student creates goes to the university. So if the person is writing a dissertation, that's their writing, so that's creative, that they probably retain the copyrights in that work. But that's a really unique question, and so you'd have to really dive into, what agreements did you sign when you agreed to go to the university and all this stuff. Because at the end of the day, if there's something in some contract that you signed, that might control and override what my gut thinks about that one. All right, so in the creative world of designers, I see things marked as inspired by or similar logos. Is this copyrighted by So, people do inspired by, they make logos similar. So the issue question is always, is it confusingly similar? How close is it? So, if there's a butterfly with the bright and brilliant colors of the Encanto movie, just because that butterfly was in a short scene of the movie, although I was only half watching it with my kids, so I think maybe the butterfly's in more than just a short scene. But they may be able to show that they have trademark rights in that, right? If they can show that they created that and people think about that, they might have some trademark rights. Is that enough for them to say copyright? It might be. Again, it's a lot of factors, and they're going to have to look at how much you took. When this happens in court, they go through, and like books are an easy example. They look at the similarities and go, okay, well, your story takes place in New York in the 1800s and involves someone from high class society and someone from low class society, and they look and see, all right, well, they start with the broad and get to the narrow. And so, would someone think the butterfly design is copyrighted by Disney? It could be, and they might, and they're a big company that might want to protect all their marks. Okay, so I could make a website called shoes.com without needing to trademark it. Yeah, provided if you're selling shoes, that, and you wouldn't be able to trademark it. So you could do shoes.com for shoes. You wouldn't be able to stop other people though from doing that, because you wouldn't have any protection. That's generic for what it is. All right, comment on LeBron trying to copyright Taco Tuesday, and they said no. Well, that's good, because the Smith House would infringe every Tuesday. All right, I haven't been to Dominic's in forever. Jewel, yes. Can I trademark a dance? I in theory, I think this actually came up. I know that there are Fortnite dances or something like that, but this came up not with Fortnite, before that, with touchdown celebration dances, actually, that the professional athletes were trying to copyright those, and this issue of can that be copyrighted? So I mean, you can copyright a dance, a long ballet, that's protectable as a copyright. A trademark, maybe. You'd have to show though that they see that dance, they think of some goods or services, and you'd have to use that dance in in association with the goods and services. So I suppose if you had delivery drivers that did a specific dance every time they dropped something off, maybe you could say that was protectable. Let's see, what about material you create? Intellectual property, what's the best type of protection for this? Well, again, it depends. It depends on what you've created, how you've created it, and what it's doing, right? So if you create a logo, but you don't use it, well, you might have copyright protection in that logo, even though you're not using it. When you start using it, you might have trademark protection of that logo. So, the material you create and how you protect it is really what you need to sit down and look at, because depending on how you protect it, that's going to dictate the next steps you take for protecting it. All right, I don't know what this question means, artificial intelligence solutions, but I'm going to wonder if that has to do with like patenting stuff. So there are ways to get patents on using AI for things. An issue that's popping up now is, what about AI inventing things? And I believe the current position of at least the US Patent Office is a person has to be an inventor. And so if you remember that the monkey selfie case, where somebody threw the monkey the phone and took a picture, or maybe the monkey took the phone and took a picture, I don't know. That case ultimately came down to, well, a person didn't take the photo, so no, there's no copyright. So I think patent is kind of going that way, but that is relatively new law, so it could change. That could change daily. If you made screenshots of information presented, so that infringe on the protection. I do not plan to sell or use that. So this kind of goes to commercial use. So it depends, right? If it's just trademark stuff that's in the presentation, like if you took the presentation I did, I don't think I have anything that I would consider copyright. So, you know, there's no commercial use if you don't infringe trademarks if you're not using something commercially. So, you know, if there were a bunch of copyrighted images in a presentation and you made copies of those images, then technically that would be copyright infringement, but maybe they gave you a right to use it. So copyright infringement doesn't require, you know, commercial use. It's just a copy. All right, so ways to get around a likelihood of confusion refusal. So I'm guessing someone got a rejection. So when you file a trademark application, the government is going to ask, they're going to do a search and look at the records and look at older marks and say, all right, I'm going to look at marks with similar goods and services and kind of compare the two. And then they say, I think this is too close. I think it's not close. So the likelihood of confusion refusal is the government saying, now we're not going to let you get this trademark. It's too close to the earlier one. So the ways to get around that, you know, it's really fact specific. The TMPEP, which you could find online, is the manual that's used, and they go through and list the factors. But typically what I do is I look at similarity of the marks, and if they're not similar, or I find the dissimilarities, point those out. And then the similarity and dissimilarities of goods and services, and point those out. And that's typically how you gotta do it. You have to get around it. And I wish you luck. It can happen, it does happen. I will note that in the patent part of the trademark and patent office, the patent examiners are all engineers. Some are attorneys, but most are just strictly engineers or PhDs or people who have a technical background. On the trademark side, all those people are lawyers. All those people are lawyers. They may be engineers too, but they think like lawyers. And so that's one difference between the two sides of the same department or office, the patent and trademark office, is that the people examining have a different educational background. Let's see. Can a computer simulation process prove concept? Yeah. So if you have a patent, an idea for a patent, and then you do computer simulation to prove that it works, you can throw that computer simulation information into your patent application, and it's very helpful to do that. Will I be sending the slides out? I don't, but I think they're made available. I also think this gets recorded and uploaded on the YouTube site, because I saw my previous one. So you should be able to find this presentation when it's done and find the slides if they don't send them out after this. All right, I'm going to jump over the Q&A real quick. Let's see. So this dissertation I answered. How can I be sure I'm not misusing a print for my logo before printing? I'm not sure. Okay, so if you have a logo and you want to make sure, you can do a search. You can hire a company or call an attorney, and you have a company do a search. They'll search for prior registrations. They'll search for common law uses. They'll do an internet search. They'll do all these things and give you a report. I could give you an example. It's over on the other side of my desk, but you can do that before you do your stuff to make sure no one's doing it or you're not close enough. That's something you can do. Are nursery rhymes and Disney characters still copyright trademark? So that, again, it depends on each individual character. I think somebody, maybe it was Steamboat Willie, was coming up on the expiration of the original copyright. But I mean, like any new Disney characters, you know, there's 90 years or 95 years, they're not, they're still protected. For coloring books and stuff like that. Yeah, those are probably going to be protected images that you can't use. So DIY activities, So if you come up with a new activity for somebody, can you protect it? Probably not by copyright or trademark. I mean, if you came up with a new worksheet, a new coloring page for someone, well, you know, I came up with a princess, my own, I drew it myself. Well, that's fine. Yeah, I copyrighted that, I protected that. I can't copy a princess that exists already. I hope you got back to work okay. I think they, like I said, this should be made available, and you'll be able to find this and get my information. Let's see. Can I provide an example? Within 30 days of publishing. Okay, so what happens when you file a trademark? The trademark office will then publish them and say they have a register, and every month or every is it Tuesday? I forget how often they do this. They publish them and they tell the public, hey, we're going to let this we're going to register this trademark. If you have an objection, make it now. That's because there are specific procedures to challenge these. So if someone, let's say I've been using a mark, but I never filed for the registration, and someone goes and files for a registration, 10 years after I've been using this mark, and I find out about it, I'm given a small window where I could file what's known as an opposition and say, hey, hold it, I've been using this mark, don't give them that trademark. There's stuff you can do after the fact as well, but every trademark that's been registered is going to go through this publication process where people can oppose it, the public can oppose it. So that's really all that says. And people can get an extension. There's 30 days, someone can come and ask for extension. And then you fight about it for a little bit. So this happens. Is a program design a trade secret? Like a computer program design, it could be. The high level architecture of the software could be a trade secret. It could also be protected by copyright. You can file for copyright to protect software. You could also, if it's a new way your software works, you might be able to get a patent. But when you file for a patent, eventually that's going to become public, right? And so when it becomes public, you'll get a patent, maybe, or maybe you won't. But at the time it becomes public, you can't say it's a secret anymore. So it could be a trade secret. It could be protected by other things. Something to think about. Can you get a trademark registered on your name and then later add your mark logo? Is the latter not necessary? Absolutely, you can do this type of layering. So if I have a logo and a name, I can get one on just the name. I can get one on just the logo. I can get a third where I combine the two. And so a lot of times what I counsel, companies starting out is we got to find the core. What do we really like? Are we going to change our logo? We're going to change our name. Where is the best protection? Let's start there. Okay, let's do that first one. And then maybe we do the second one. There are benefits to doing multiple because it's confusingly similar. So if somebody's going to be bad and try and copy you and kind of ride on your coattails, you want to have as many things to throw at them to stop them. So there are reasons you want to file multiple, not necessary, but necessarily important, but there are reasons you want to do that. And downsides to using the name while you're applying, absolutely not. So if you file a intent to use today and 3 weeks from now, you go, you know what, I'm ready, let's go. There's no downside to doing that. And again, I'm speaking with no one else is using this. But if you filed an intent to use trademark application and then start using it, that's fine. That's okay. What is the difference in filing for regular patent versus provisional? So again, a provisional patent is just a placeholder. So in the risk of aging myself here, you used to have to buy concert tickets by standing in line, and you used to have friends who you could pay to stand in line for you because you did not want to get up at 7 a.m. to go stand in line, right? That's what the provisional patent is. It's you're paying your friend to stand in line for a year and say, hey, hold this spot. So the provisional patent tells the patent office, hey, Pat has an application, hold that date for him, right? You have a year then to do the full patent application and file that. If that year goes by and you don't do anything, the provisional patent application disappears. It's never examined, it's never made public. until you file a full application. If you don't do anything and you don't tell anyone about it, no one's going to know you filed it. So I hope I got your question answered, CL, or if you're able to watch the video after the fact, and hopefully I got to it. Is an attorney needed for a trademark application? Actually, it depends. If you're a US-based entity, then you don't. If you're outside the US, unfortunately, due to like glut and filings, the US, the trademark office is kind of changing the rules a bit, and you have to be represented by a US attorney. But if you're a US company or person like that, you can file the application yourself. Same thing with a patent application, actually. An inventor can file a patent application by themselves. Copyright application as well. You do not need to have an attorney represent you, with the exception of this foreign trademark applicant issue. This is a pretty new change. You can do it yourself. The information they need is pretty basic. It's the company name, who owns it, first use date, if it's being used in commerce or not, what goods and services are there. I will say the biggest mistake I see people make when they file their own trademark application is they file an intent to use application, and then they mess up who the owner is. And this is important because you can't assign this. So if you mess up the owner of the intent to use application, it can mess up the whole process. So if it's your company that is the company that's going to sell stuff, they're the one that's using the mark, they're the owner of that, they're the applicant of that application. You may be the president of that company, but that means that the applicant is the company. And if that gets messed up, there's nothing we can do. You might lose that filing date. So you don't need an attorney to file these, but just read them carefully and make sure you answer the questions asked. So, okay, I think this got clarified my question. Can AI solutions be patented? Potentially. This kind of falls into software. You have to show all this information and go and prove. Unfortunately, this is kind of swept up in this pendulum of the software patents. So it is possible to do it, but it can be more challenging than a new cup or something like that. But it is possible. There's no per se rule that says you can't get a patent on an AI solution. If you trademark a name, but someone was using that name on, do I have to pay them, or no matter what? Well, it depends, right? So just because someone's using the name doesn't mean that they've created trademark rights. They have to use it in commerce, so it has to be used in association with goods or services. So if somebody was using some name, I don't know, Jub, in a non-commercial sense, then I don't know that they necessarily create trademark rights. There is an area of law, an unfair competition area of law that's created under trademark statutes. And maybe there'd be something there, but if they're not using it as a trademark, then they don't have trademark rights. And do you have to pay them or not? That you can get agreements with people. Someone asked about this opposition thing. Sometimes what happens is I file for a trademark and somebody else has an application too, and the office thinks they're close. Well, I can tell the other side, hey, I've been using this longer, I'm gonna oppose yours. Unless you and I agree, we can both use this and no one's gonna be confused. If I have an agreement with someone, the trademark office tends to agree with those and goes along with it. So that's something you might be able to do, or if it's something you're concerned about, you know, it may be easy just to do it up front. Just say, you know what, I don't know if they have rights, but here, I'll pay them $10, get them in writing to say, hey, they're not going to bother me, and move on. You know, sometimes it's not about whether they have rights. Sometimes it's whether you can avoid them asserting they have rights later on. Okay, I talked about the likelihood of confusion. Where will be? I think there's a YouTube channel that has all the webinars that you can access them all, not just this excellent one. If a product dimensions and standard across image, they all look the same and similar, and I use it as infringing a shower base. Like you taking an image of a shower base that someone else drew. You know, I don't know. It could be, you know, you don't know where you go to a website and you see an image. You don't know where they got that image. And, you know, whether that's their image or somebody else's image or somebody else's image, or, you know, how far down the line you go. So you have to think about it. And again, filing a lawsuit is expensive and it's a pain in the butt. And so, you know, you have to kind of do this balancing and say, you know what, I took this image from the internet, but what is the likelihood someone's gonna sue me? And that's not to say you should just copy images at all. People are out there and they will enforce rights pretty heavily, but you know, it's something you have to think about. So it's, you know, it's a business decision. They have to decide whether they want to use it or not. Okay, what if there's a trademark registered the same as my name, but in a different state and a different product and services? Can I still file for trademark? So trademark analysis, this likelihood of confusion, is going to look at basically the goods and services in the mark, right? So if the mark is identical, how close the goods and services have to be they don't have to be as close. Whereas if the mark is somewhat different, you know, then the goods or service can be a little closer. So, you know, it's really hard to say if, you know, on the one hand, the products and services are shoes, and the other hand, they're auto repair maintenance. I don't think those are ever going to be considered similar services. So companies could both have the same trademark for different, you know, for those different goods and services. If you remember my kind of ranking of how Wordmarks go, though, if that mark is an arbitrary term like the jub, or like if you were going to do, you make up a term, and you know, that might be a different outcome, because you know essentially they're going to ask the decision maker is going to ask themselves, well, how likely is it that the second person came up with that term on their own? And you know, if it's something that's arbitrary or completely made up, you know, that they might be willing to give that brand owner a lot more protection than if it's something that's descriptive or suggestive. So I think I got all those now. And I believe that's it. So
you answered all of the questions. I was following you along. It looks like you were able to reach everyone.
yeah, I hope I did. And as I told everyone, when you access the slides or go on YouTube to view the video, my email address and cell phone number are on there. And you're more than welcome to shoot me an email or give me a call and ask you know, question. And I like talking about this stuff. I could probably go on for hours, but I won't. It's Friday, and so you all probably have more fun things to do.
Thank you, Patrick, for your informative presentation today. If you would like to receive credit for today's webinar, please send an email to bacpoutreach@cityofchicago.org. Again, that email is bacpoutreach@cityofchicago.org. To find out more about our upcoming webinars, please visit chicago.gov/business education. Again, it's chicago.gov/business education. Thank you again, Patrick, and everyone. Have a great weekend.
Thank you, everyone. Bye.